The state of New Hampshire has one of the strictest conflict of interest laws relative to nonprofits in the country. It's called RSA 7:19-A. And what it says is the following: that yes, there may be conflicts of interest when we're talking about a nonprofit board, and to define that, that means a board member doing business with the organization on whose board he or she sits and receiving money as a result of that relationship. That's what we're talking about. Let's talk about the levels. There are 3 levels of what we call pecuniary benefit. In other words, you're receiving money for your service. Number 1 is the $500 limit. If I'm a board member and I'm sitting on the board of a youth sports organization, let's say I'm a t-shirt salesman, and I want to sell my t-shirts to this organization. If the amount of my t-shirts in the aggregate per year cost $500 or less, there is no conflict of interest. The law specifically states that. If, however, my t-shirts cost between $500 and $5,000, I now have 3 things I have to do. Number 1, I as a board member have to disclose my conflict. Number 2, I have to leave the room. I cannot participate in the discussion nor the vote. And number 3, if the board of directors chooses my contract, that board has to reduce to writing in its minutes the reason it chose my contract. If, however, my t-shirts cost more than $5,000 in the aggregate per year, I do everything at the previous level, but I also have to publish a legal notice in the newspaper. Now, it's important to understand there are 2 components to that notice. Number 1, for purposes of publication, I am publishing the total amount of the transaction, not necessarily what I'm receiving. So it will be the total amount of those t-shirts. But number 2, I have to report to the Attorney General's office the pecuniary benefit that I, the individual, receive as a result of that transaction. 2 other important points. First of all, if you have a board member that either wants to sell or rent real estate to the organization or vice versa, that has to be approved by the probate court. Number 2, you can never lend money to a member of the board of directors. The reason for that is because if you have a board of directors member that can't obtain a loan at the bank, that person is probably not a very good risk. The penalty for this is if that person defaults on that loan, then everyone who voted in favor of it is now responsible to pay the loan back to the organization. So it's a very severe punishment for engaging in that kind of activity. Every organization must have a conflict of interest policy, and the board must renew those conflict of interest policies every year and notify the Attorney General they've done so. Conflicts of interest can be direct or indirect. If we're talking about a direct conflict of interest, it means the board member, himself or herself, is receiving a pecuniary or a monetary benefit. That, however, can extend to an indirect pecuniary benefit, which would include anybody related by blood or marriage to the board member. The IRS also calls this a related party transaction. And in the state of New Hampshire, if I had my husband engaging in one of these activities, again, I would need to report to the board my conflict, recuse myself, make sure I'm not voting on it, and have the board acknowledge the fact it is a pecuniary benefit conflict of interest transaction.